In the state of California, you as an employer do not have to actually provide vacation for your employees. The legislature has flirted with the idea several times and so far hasn't required that that be part of the employer relationship. However, if the employer chooses to make that a benefit that they provide to their employees, there are certain restrictions that the Labor Code actually forces upon the employer. Labor Code Section 227.3 states that you cannot have a use it or lose it policy. The cases that interpret that section and the section itself state that in the instance where an employee has accrued vacation time, they cannot simply lose it if they are involuntarily terminated or if they resign. They're considered wages, and so the employee ends up having to go ahead and be paid those wages at the time of separation. And if it's vested, the employer then has several choices. Either they can go ahead and create a reasonable cap, or they can pay it out yearly so that it doesn't continue to accrue into this large, unknown, unanticipated liability the employer has if that employee decides to leave at the end of a school session or at the end of a situation where they want to move because it's the end of the busy season and they're no longer going to work in your restaurant. And lots of employers do not want to have that liability on the books and carry it for a long period of time. The Labor Commissioner takes the stance that a reasonable cap can be 2 times the yearly accrual rate. So for instance, if an employer has 1 week vacation benefits that a person can accrue during the year, a reasonable cap that the Labor Commissioner currently says is okay is 2 times that, where an employee will not continue to accrue beyond 2 weeks in that instance. The other option, obviously, that I mentioned before is at the end of the year, December 31st, if you're on a yearly accrual basis, you can go ahead and pay out whatever vacation is left for the employee at the time, and everybody starts over January 1. Those are the options that the employer has. In the end, you simply can't have a use it or lose it policy under the Labor Code 227.3.